entertaining and informative radio for the Sunshine State.
It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Hello and good evening. We are back once again. That's right, FLA Law on the radio. My name is Jacqueline Bryant. I'm one of the personal injury attorneys at Perinick, Caulfield, Averill, and Noyes. And today I'm here with my co-host, and he is?
I am Matthew Noyes, and I'm happy to be here. I missed last week, but I'm glad to be here this week. Thank you, Jacqueline.
Hopefully you got our message. Did you win?
He did win, and awesome. I did hear it, so thank you. Maybe that's why you won.
We had to send a little
We had a game down in Sarasota. So
Yes. So he's back again this week, and of course you have two legal minds here to answer your legal questions tonight. As you know, hopefully you're a repeat listener. You have been hearing us here every Tuesday at 5 o'clock to answer your legal questions in regards to things going on in your life that might be legal related. As you know, we are personal injury lawyers. So a lot of our conversations have been focused on car accidents, slip and falls, and those that fall into that personal injury realm. But of course, we can touch on whatever things that you may have questions about. So I'm going to go ahead and give you the call-in number for tonight, which is the same number every Tuesday night. It's 441-3000. That's area code 727-441-3000.
And what we see often is that people start calling near the end of the hour. Mm-hmm. So if you want to get your question in and get some answer from two attorneys, at no cost whatsoever, give us a call now.
Yes, and we are also streaming. We're doing a couple new things tonight. So we are streaming live on Facebook, like always. So if you are on Facebook, go ahead and look for us.
There.
Yeah, you can see us on the camera. Perinick, Caulfield, Averill, and Noyes Injury Lawyers. That's how you find us on Facebook. But if you're looking at us tonight, we are also on Instagram. So we're doing something new. We don't have a lot of room in the Instagram video, but you can find us on there at PCAN Personal Injury Lawyers. If you're on IG, look for PCAN Personal Injury Lawyers, and we are live there. You can comment live. We will answer your questions on the air, right, Matt?
That's right. I'll have to defer to Jacqueline, though, on Instagram because I don't know how to use that.
So we're looking at it. I think the questions will pop up just like Facebook. So if you're there, we will definitely take a look at your questions and answer them while we're in the studio here. We also have a live YouTube video that's also running live on our YouTube right now as well. So that's another thing we've added. So you can catch us on all these platforms, Facebook, Instagram, and YouTube tonight. And leave your questions, and we will answer them live on the air.
And on the radio, right here.
Exactly. So we would love for you to call in and hear your voice on the radio.
Yes, we used to do this on TV a long time ago. The firm used to do FLA Law on TV. We took a live call-in talk show, just like we do on the radio here. It was a lot of fun. I must admit there were a few times that defense attorneys on my cases would call and try to trick me up with some questions and such. But somehow we settled those cases the week after because they knew we knew what we were talking about.
Well, that's good. They're trying to get some intel on their opponent, huh?
That's right.
Well, with radio, obviously, we never know who's out there listening. But hopefully, if you have any questions, you are not afraid to call in. Defense attorneys, please don't.
Bring it on. I say bring it on. Let's do it.
All right. So tonight, I think we're going to talk a little bit about some work comp issues. But before we jump into that, I think we already have a live caller.
Look at that.
Let's go ahead and take our first call before we jump into some extra topics. Caller, are you there?
Yes, this is Mark from Largo.
Hi, Mark from Largo. How are you?
Yeah, good. Thanks for taking my call.
Absolutely.
I had a question about a friend of mine that was working as a driver for a pizza company, and he got in a car accident at the same time, and he was confused as to what workers' comp would pay for and also the auto insurance.
Excellent question.
Very good question, Mark. Thank you very much for calling and listening. That is something that we deal with a lot because we do both workers' compensation and automobile liability. We see that a lot. And actually, your friend would be entitled to 2 causes of action, one under workers' compensation and a liability claim against the at-fault driver insurance company who caused the crash. So he would be entitled to treat under workers' comp. Workers' compensation gets to pick the doctor, unfortunately, but he is entitled to workers' comp benefits. And he is also entitled to his PIP coverage or personal injury protection coverage under his auto policy. And he can pick his own doctors if he treats under PIP.
Right. And so essentially,
I think he said he wanted the workers' comp doctor he went to, but he didn't like them very much.
Right.
And he wanted to pick out his own doctor, so he wasn't sure if he could, go to his own doctor. He had to go to the workers' comp doctor.
Right. So normally he would be, unfortunately, under the work comp system, he would have to go to their doctors. But because it's an auto case as well, he does have that right and that choice to treat under the PIP coverage, which would allow him to choose his own physicians, assuming they take the PIP, which a lot of providers do. And he can choose his own physicians that way. So it can get tricky keeping both claims open at the same time and deciding which benefits to use because he's entitled to both. So I definitely would encourage him, especially if he's not at fault, to give us a call so that we can kind of walk him through the process so he knows the best doctors to select under the PIP and also how to navigate still keeping, his entitlement to the work comp benefits as well, because he wants to kind of preserve both.
Exactly. And what we always tell our clients is to make sure that the workers' comp doctor knows about the PIP doctor and the PIP doctor knows about the workers' comp doctor. That way, neither doctor could be surprised if they're asked about other treatment that's being rendered.
Right.
Does that help?
Well, I sure appreciate your show, and you guys have been very informative, and I appreciate it. I'm going to definitely tell all my friends to tune in.
Thank you, Mark. We appreciate it.
Thank you.
Oh, I got to say one more thing. Rays are off to a good start. I got to say, let's go Rays.
That's exactly right. It's a wonderful start. We are bound to win 180 games, I think. So it'd be wonderful.
That would be great. Thank you both very much. Have a nice afternoon.
Thank you.
You too. All right, great.
That does free up a line. So if you have a question, give us a call at 727-441-3000, and we're here to answer any questions that you have.
Yeah, and that was a great question because that actually leads right into the topic for today, which is what we were going to be chatting a bit about was workers' compensation. And the reason why I think it's a good topic for today's show, because there's a lot of traps for those that just don't know the system. And people think it's similar to a personal injury claims and that they get a lot of the same rights and remedies, but it's actually not. And it's quite different in the sense that you don't really get to control your medical care or treatment.
That's exactly true.
And I think I get a lot of work comp clients who are just completely confused and, misled when they get into that system. So I thought it was good to kind of touch on that today, right, Matt? I know you've done workers' comp for a long time.
Yeah.
and so I think that would be good for you today as my co-host to kind of jump into some of those topics.
Sure. We do see a lot of workers' comp claims. We see a lot of people get hurt while at work. And what's important is not only that they know what their rights are, but also what their responsibilities are.
Exactly.
Too many times, the injured worker doesn't do what they're supposed to do in order to be entitled to the workers' compensation coverage. And one of the most important things they need to do is to report the accident.
Oh, yeah.
They need to report the accident to their supervisor, not to a coworker. Not necessarily to the insurance company, but they do have to report it to their employer.
Right.
If they know their insurance company, then it's good for them to report it to the insurance company as well. But that's only the first step. The second step they must do also is to make sure that they request medical care. Workers' comp does not have to provide you with medical care unless you ask for it.
Right.
Too many times they come and they say, I haven't seen a doctor. And so we say, well,
did you ask for one?
Did you ask for one? And they said, well, no, not really. And so before we can hold them responsible to provide doctors, you have to ask for one.
Right. And so with that being said, when they ask for a doctor, do they get to go out and choose that doctor as you might expect?
No, unfortunately, they don't. Workers' comp gets to choose the doctor. Kind of like what Mark's question was earlier was what if I want to go see a chiropractor if I get hurt in a car accident?
Right.
Well, under workers' compensation law, chiropractic care is very limited under workers' comp. It's not limited under PIP, and which is kind of surprising to me because
isn't it like 12 or 20 visits?
It's like 24 visits now.
Yeah.
But people get better results in certain injuries through a chiropractor, and it costs workers' comp less.
A lot less.
But they still refuse to authorize the required chiropractic care. So workers' comp gets to dictate who you see and when you see them, quite honestly.
Exactly. And so let's say we get with our authorized doctor and we find who that is. Is there ever a chance where, let's say I didn't like that doctor. He wasn't that great. I think I want to try somebody else. Is there something you can do under the work comp system?
Well, workers' comp is purely statutory. The statute, chapter 440, tells you exactly what you can do. And in fact, chapter 440 says, no, you don't get a second opinion under workers' compensation. Wow. You get the doctor that they select for you. And if you want a change of doctors, you can do a change of doctors.
Right.
That sounds like a second opinion. Well, no, not really.
It's not.
No, because what happens is the first doctor is deauthorized. You can't go back to that first doctor.
Right.
And the second doctor becomes the authorized doctor. But who gets to pick that doctor?
Right.
Workers' comp gets to pick that doctor as well.
Took the words right out of my mouth.
Yeah.
So once again, you are now stuck with who they chose and who they selected for you. And I don't know if you said the word, but the key is it's a one-time change.
Right.
I think you did. So that is literal. It is literally a one-time change.
For the life of the case.
Yeah. And so a lot of people don't understand that. And a lot of times they'll come to us after they've asked for a second opinion. And they're like, but it was just a second opinion. I thought that I was just going to get a consult. And they don't realize that, nope, the doctor you were seeing before has now been deauthorized. You cannot treat with that doctor anymore, even if his opinions or her opinions were better.
Right.
This new doctor is now the authorized treating physician.
Right.
And now their opinions are the one that will basically reign in your case and are the ones that the carrier are going to go off of. And you can't go back to the other physician, even if you decided that I think I like that guy better or that one better.
Well, and the thing is, if it's a walk-in clinic and you want to change, if you eventually get to an orthopedist or a surgeon, then you've already used your one-time change.
Exactly.
Recently, I had a client come in and said, well, I didn't like the physical therapist that they sent me to. And so I requested my change of physical therapist.
So it's not per specialty. So you don't get to change for physical therapy.
It used to be.
Then change for,
it used to be, but not anymore.
Yeah. So that's definitely, I think, a key that people miss, because a lot of times people aren't used to not being able to control what doctors they see.
Right.
There's very few systems where that's the case. If you have health insurance, you can choose, if they're in your network, you can choose your own doctors.
Right.
So to be limited in that way, people just think that I've got to be able to get a second opinion, right? What if I go see my own doctor?
Right.
And so what do you tell people when they say, well, I saw my own doctor, my own primary care physician outside of the system? How does that work in the work comp?
It would be as if you never saw that doctor. The judge would never be able to hear the testimony of that doctor, never be able to see his report or hear his opinions. Nor does the workers' comp carrier have to follow anything that doctor says. It would be as if you did not even see that doctor of yours.
Why, though? That means that doctor's credible, right? They've got a license to practice medicine. Why can't we use that?
It doesn't make sense. But the statute does say that there's only three types of doctors can testify in a workers' comp case.
And that's the authorized treating physician, the IME, or the EMA doctor. That's it.
That's it.
Even if you got the best doctor in the country who saw you, evaluated you, said it was work comp related and that you need a surgery and that it should be related to the work accident. If they're not the authorized treating doctor, they're not the IME doctor, or they're not the EMA, they do not come in. It doesn't come in.
Right.
It's inadmissible.
That's right. And an IME is an independent medical examination.
Right.
You do get to pick an independent medical examination.
Okay.
But you have to pay for it now.
Right. So I think we'll come back to that because that's a good point.
Yeah.
It looks like we do have a caller on the line calling in. Caller, can you hear us?
I can hear you. This is John from St. Pete.
Hi, John. How are you? Go ahead with your question.
So I am just curious as to whether or not work comp would apply in this situation I found myself in recently.
Okay.
I work at a small office down in St. Pete, and I took our mail to the local FedEx to ship out. And at the FedEx, I tripped, and I just stumbled over my feet and banged up my knees pretty good. And I'm getting some pain in my knee. I think I got to get it checked out.
Mm-hmm.
Would work comp apply if it didn't happen, like specifically at work?
Good question. So it sounds like you were in the course of doing a delivery or a package drop off at the time. Is that right?
Yeah.
Okay. So then in that regard, depending on the number of employees, they have at your firm, I think you said it was a small office that you work for, but as long as you are in the course and scope of your employment and you're actively furthering the business of your employer, then that should qualify.
Well, what usually happens in those types of cases, though, what the argument is no. He's off premises. Mm-hmm. He's clocked out and was delivering that package on the way home.
Oh, okay.
And so they tried. So the carriers.
I missed that fact, John.
Yeah.
Sorry.
Well, I don't know if that's a fact in your situation, but that's what I see.
It did happen around right when I clocked out of work.
Oh, okay. So that's definitely an argument they can.
That's an argument they make, but they lose on that argument because it's a special errand.
Yes.
And so since you're doing a special errand and you're furthering the employer's mission, then you would be entitled to workers' compensation benefits after that. The fact that you're clocked out doesn't
really matter. Yeah.
No, doesn't matter in workers' comp. If you were in a building and you clocked out and you were walking to your car in the parking lot and you tripped over the parking bumper,
even though you were done for the day,
even though you were clocked out, you would be entitled to it. Or if you hadn't clocked in yet, but you were still on the employer's premises, you would still be entitled to workers' comp coverage.
Yeah, so definitely report it and make the claim because it does sound like you meet the parameters with just what you've told us so far that would qualify under the workers' comp system.
Okay, I'll be sure to do that.
Thank you. I appreciate you calling in. Did that answer your question?
That answered my question. Thank you guys so much.
You have a great night.
Thank you. It does free up a line. The number is 441-3000. Give us a call. We're here to answer your questions regarding car accidents, workers' compensation, Social Security, disability, and any type of questions you may have. Jacqueline and I have kind of handled all kinds of questions, even though we specialize in personal injury.
Yes.
But we're happy to at least address a question that you have and give you our 2 cents.
Right. And soon we'll be having different areas of law coming onto our show and giving comments from other attorneys that practice other areas other than personal injury. So if you have a good question that maybe doesn't fall into that category, we can definitely make sure our guests in the future try to answer those questions for you. So keep listening every Tuesday. I'm taking a look. We're still here live on Facebook and IG. So if you have any comments or questions, definitely drop those in the chat box as well.
Yeah, I just want to talk about John's question. I'm going to just add a little bit to that question.
Yeah.
And that's what if you're in an automobile accident on the way to work?
Right.
Or on the way home to work, from work.
Right. Well, it's a bit different.
Yeah. The going and coming rule would disqualify you from workers' compensation benefits if you had not yet entered into the employer's premises.
Right.
But once you enter into the employer's premises, or if you're in between offices.
Right.
If you're in between offices, you would be entitled to workers' compensation. What does that mean? Well, sometimes if you're a traveling nurse
Right.
and you went from one patient and you were driving to the next patient,
Right.
that would be covered under workers' compensation because although it's not on the premises, it was
Exactly.
going from one office to the other.
Right. So the key takeaway, I think, is just because it's off premises doesn't mean that it's excluded. So if someone tells you, oh, you weren't on the job site when it happened, but you were still actually working when the accident occurred, then you should definitely call us and let us kind of walk you through the work comp system and try to assist you with that.
Workers' comp carriers want to deny your case as soon as they can.
Yeah, absolutely.
And so it's our obligation to really try to find coverage when you're entitled to workers' comp.
Right.
Workers' comp benefits aren't the best benefits. They're not that good. But they are benefits that an injured worker are entitled to.
Right.
And so I always tell the clients, listen, I can't get you more than the statute says, but we can be darn sure that we're going to get you everything that you're entitled to after a work injury.
So let's get more into what the statute says.
Yeah.
So there's a lot that the statute says. So I want to try to keep touching on some of this. And of course, as the questions come in, we'll try to answer those. But we did talk about IME right before we took that last call. And so we were establishing you can't pick your own doctor. There's just very few ways to do that. But what's an IME? Can I select that doctor?
You can select that doctor.
Okay.
However,
Finally, no.
no, because there's still caveats to that, unfortunately. In the law, there's always seems to be caveats.
Oh gosh.
But you can select the doctor,
Right.
but it cannot be a treating doctor.
Right.
If it's a treating doctor, then the employer carrier can reject or object to the IME.
Right.
And the judge would likely not allow him to be designated, him or her,
Right.
to be designated as the IME.
So if it's a doctor that you actually want to treat you and provide the care that you are looking for, then you don't want to have that doctor be your IME because they can't. They're doing a one-time evaluation to assist with some issue in the case,
Right.
Whether they're giving an opinion about causation or your limitations or whatever the case may be. They are not actually going to be the ones that provide you treatment. And as Matt had touched on before, you have to pay for it.
Yeah, that's new in the statute. Well, newer in the statute. Before, because the benefits are so limited, it used to be that the injured worker was entitled to an IME, an independent medical examination, and the work comp carrier had to pay for it.
Right.
But they changed that now, and now the injured worker who may not be working or maybe working and only earning 2/3 of their income, although they have 100% of their bills, who may not have the funds to get the medical care, now is required to pay $1,000, $2,000.
Yeah, I was going to say these aren't cheap.
Dollars, even up to $5,000,
Very
depending on the
expensive.
doctor, to have the IME.
Right.
So it's a disincentive to injured workers. It sounds good to, hey, you get your IME,
Right.
but when you read further in the statute, it shows that the benefits aren't as equal to the injured worker as it is to the employer carrier.
Right. So before we take a break, I wanted to ask then. So I get my IME doctor. We're taking you through all the scenarios here.
Yeah.
I get my IME doctor, and he says what we've always felt, which is it's causally related. He gives all the good opinions that we are helpful to our case. Correct?
Right.
Does that mean I win now?
No, you got one more step.
Oh, God.
Well, hopefully the insurance company sees that
Right.
that doctor is right and the
Exactly. We'd hope.
workers' comp doctor is incorrect. But that never happens.
Darn. So we get conflicting opinions. Then their doctor says something that we don't believe is true. We get our IME, who we've now paid thousands of dollars for to try to help us. They are in our favor. Now what?
Now what happens is that they appoint a EMA. Workers' comp has all these initials. After MMI, you can see an IME, or you can see, they're going to get TTD, but then you can get an EMA.
Just don't ask for that OTC.
That's right. But the EMA is the expert medical advisor.
Okay.
And the expert medical advisor is a super doc, so to speak.
Yeah.
The judge appoints the expert medical advisor if the parties can't agree to it. And then that doctor, the EMA doctor, will render an opinion. And the judge, in most situations, has to follow with what that EMA doctor says.
Right.
So it's a risk to both sides, actually. It's a risk to the claimant, the injured worker, and it's also a risk to the employer carrier.
Right. And then that settles it, right?
That settles that.
Good. So I think that brings us to a good stopping point. Take a quick break. We will take a short pause here, 2 minutes, and we'll be back shortly to answer more of your legal questions. When we return, that's 441-3000. Give us a call.
Thank you.
This is the TAN Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
Hello there, Tampa Bay. This is former NFL and college football coach Jimmy Johnson. Listen to the Kelly Show every Monday starting at 5 p.m. They can sure use the attention.
And this is former Major League Baseball player, Hall of Famer Wade Boggs. I also hope you listen to the Kelly Show every Monday starting at 5 p.m. They can darn sure use the money.
Hi there. This is marine wildlife artist and conservationist Dr. Guy Harvey. Please listen to the Kelly Show every Monday starting at 5 p.m. They need to feel worthy.
This is the TAN Talk Radio Network.
Welcome back to FLA Law on the radio. Just heard the commercial for Kelly. I know Doug Kelly and Kelly. They're two wonderful people. We've been on their show a few times. In fact, our firm sponsors or co-sponsors their show. So they're on Mondays at 5 o'clock, and we're on Tuesdays at 5 o'clock.
Right. And so if you have been listening, and obviously, we've been talking a lot about workers' compensation, but of course, we do slip and falls, car accidents, Social Security, disability. So any topics that you have, even if it doesn't fall within the workers' comp realm, you can certainly give us a call, and we're happy to answer those questions tonight.
Yeah, Jacqueline, we have been dealt with every time there's a personal injury case, there always seems to be another area of law that can be tied into personal injury. That's one of the reasons why I love personal injury as much as I do.
Right.
Because it can turn into a probate question. You know, if there's a guardian or if a minor settlement.
Absolutely.
It can turn into a family law question if there's a divorce in the middle of a case.
Sure. Or bankruptcy.
Or even a minor getting injured from divorced parents who runs the show.
Who's going to be the one to kind of step up, right?
Yeah, and there's tax law that comes involved when it comes to settlement. So personal injury has all types. And then workers' comp, of course, if it's workers' comp related.
Right.
And Social Security disability, too.
And I think that's what makes our firm a bit unique, too, is because we do a lot of those under one roof. So your Social Security and disability can be handled at our firm. Your workers' compensation can be handled at our firm. And a lot of personal injury attorneys do not do that.
Right.
They end up having to refer out those components, which unfortunately can make things a little bit disjointed when they're not all handled together.
Yeah. So. And since we've been around since 1955, we are the oldest personal injury law firm in Tampa Bay. But since we've been around for so long, we know a lot of attorneys that do all that other areas of law.
Exactly, the tax and the bankruptcy and the family law.
Yeah, we know what we can handle. We know what we need to have other people handle, and so we know a lot of very fine attorneys throughout Tampa Bay that handle other areas of law that do a great job, and help our clients as well. So
exactly.
we encourage, even if it's not personal injury, if you have a question regarding another area of law, you just need a recommendation, you can call our office.
Keep on calling.
Yeah, you can call our office at 796-8282. But if you have a question tonight, what do we do?
It's 441-3000.
That's right.
Or you can get on our Facebook live stream, and we'll be back on Instagram shortly. So with that being said, I still have a ton more I can ask you about workers' comp. It's a never-ending story.
No, it's a constant battle. The benefits are few, but the fighting is, or the procedure, I guess fighting isn't really the right word, but the procedures to get the benefits that you're entitled to
exactly
can be so challenging sometimes. Yeah.
So the question I always get, and I had a recent new client come in with a similar question, is my doctor's telling me that I'm full duty and that I'm able to go back to work, but I can't. I know my body. I know what I feel like. So can I just stay home?
Yeah.
Of course you can.
Yeah, of course you can. You're not going to get paid, but you can sit at home.
Exactly. Bingo.
Yeah.
The paychecks aren't coming in.
Yeah. Because under workers' comp, if a doctor has you out of work altogether, you're entitled to, here's these initials again, TTD,
right, or
temporary total disability benefits.
Right.
And that pays 66 2/3 of your average weekly wage, or your AWW, at the 13 weeks prior to your injuries.
Right.
But if the doctor says, listen, you can go back to work, but with these restrictions and limitations, then you're not entitled to TTD, but you may be entitled to temporary partial disability benefits, or TPD.
Right.
But there's things that you need to worry about when the doctor says that. First, you got to see if the employer has work available for you within those restrictions and limitations.
Yeah.
And if they do have work available for you, but you're not earning your average weekly wage, you could be entitled to both workers' comp benefits and wages from your employer.
Right.
The question is, are you earning 80% of your average weekly wage?
Exactly. And so I think a lot of people get it confused when they do have those restrictions. They assume they can just stay home.
Right.
But if the employer is willing to accommodate, and they do have a position that meets those limitations and restrictions according to the authorized doctor, then you have to go.
Right.
You have to show up for that light duty position, or that's within those limitations.
Right. And I always tell my clients, I say, go, document, bring your restrictions with you. That's one thing I've learned to tell the clients, is to bring your restrictions so you can show your supervisor.
Exactly.
And say, I can't lift that 35-pound thing. Here's my restriction saying lifting no more than 10 pounds.
Exactly. And so just to bring it back to our previous point, these restrictions can't come from a different doctor. It has to come from the work comp doctor.
That's right.
Because a lot of people will do that. They'll say, well, my primary care gave me a doctor's note and they took me out of work. But unfortunately, if the work comp doctor has it,
that doesn't
count.
Yeah.
You're not going to get the paychecks or the wages through the work comp system without that authorized doctor saying it.
And I think it's also beneficial if you do try.
Yes.
Because then you can go back to the doctor, the authorized trained doctor, and say, listen, doc, I did what you said to do. And A, they made me do more than you wanted me to do.
Right.
Or B, I followed the restrictions and I had a setback every time I went back.
Exactly. So, I've seen that work a few times in my career, is that if you show that I did it, I tried it, and it actually made me worse or it exacerbated my pain, doctors tend to be sympathetic to that.
Doctors want to see people trying to get back to work. And I slam insurance companies a lot and defense attorneys a lot. But I think most adjusters also want to see the injured worker get back to work.
Right.
Why they send them some of the doctors that they chose them to, I don't know, but
I can guess. I can take a guess.
Yeah, but I think some of them do really want them to get back to work.
And that's what the system's designed to do, right?
Exactly.
And that's what a lot of people don't seem to understand. It's not designed to let you stay home and heal and be out as long as you want and take your time through that process, although that would be great. That's not what the system is really designed to do. It's designed to get you right back to work as soon as they can. Right. And a lot of times, though, patients and claimants will feel rushed like the doctors are just kind of pushing them out there and pushing them back to work. And sometimes that's true. And so that's why you have to call, us and help you assist through that process to find out, if there's other ways we can kind of work through the system. So you're not necessarily rushing back to work and you're not quite healed.
Right. I always say the insurance companies have lawyers looking out for their best interest.
Yep.
It's only right that the injured workers have the same thing.
Exactly.
But workers' comp system isn't just a benefit to injured workers. They lost a lot of rights in exchange for the entitlement to workers' comp benefits.
Well, that's true because it's a no-fault system. So I think a lot of people don't necessarily realize that even if you're at fault, you did something silly that caused an injury at work. Or I think I had a situation where a person shot themselves in the foot with a nail gun. Well, the employer didn't really do anything to cause that injury. There was no negligence, but all of his medical care and treatment was covered. If he was out of work and needed to be, that was something that was provided because it happened during the course and scope of his employment.
But if the employer was negligent and causing the person to get hurt.
Exactly.
Or if a coworker was negligent and causing the injured worker to get hurt.
Mm-hmm.
The law rips the right away from them to bring any negligence claim against the employer.
And unfortunately, it was a terrible exchange, if you will. But there are some ways to still sue the employer, but it's very, very difficult. It has to be practically intentional, acts on behalf of the employer that will get you by that. And that's almost virtually
we had a case. It was the Tropicana orange juice plant.
Yeah.
It was a long time ago. But the lady, the procedure was if the machine got stuck, they didn't turn off the machine. They had the employees reach in to pull out the carton that got stuck.
Oh, what a horrible
Because
policy.
they were saving money by not turning off the machine. So, of course, our client, my retired partner now, Bob Carroll, handled the case. He had a client that did what she was told to do, reached her hand into the cart, into the machine to pull out the clogged carton. And sure enough, it clawed her. Oh, gosh. And she had to have her arm amputated.
Oh, my goodness.
And so we brought the claim saying, that was intentional.
Yeah.
They
or
purposely.
Or virtually certain that type of result would occur when you have people sticking their hand in there.
Yeah. And Supreme Court said no.
Oh, yeah.
That wasn't.
It's tough.
Yeah, it wasn't for it wasn't intentionally to get her hurt. No, it was intentionally to earn profits.
Exactly. Oh gosh. Well, I think we've got another call on the line.
Good deal.
This is excellent. So go on through. Caller, can you hear us?
Yes, I can.
Hi. Go ahead with your question.
Hi. I noticed that you guys assist with Social Security disability claims.
Yes,
we do.
And we were looking into that filing for my mom, but I just wanted to know, do you know or can you give advice on how long approximately the Social Security process takes?
That's a very good question. Thank you for calling. Let me see if I can address that a little bit. The Social Security system is a very slow system with many steps in between. The first step would be your mom would have to apply for Social Security disability or Social Security income, depending on whether or not she has the necessary work quarters. And the first step is the application process. You have to wait to get a decision on the application process. Mm-hmm. After the application process, which are mostly denied, the next step would be the request for reconsideration. Mm-hmm. You file a request for reconsideration, and you wait, and you wait, and you wait. And then you finally get an answer to the request for reconsideration, and that's a denial as well in most situations. So then you have to do the request for hearing.
Right.
And the request for hearing, from the time you do the request for hearing to the time of the hearing, is most of the time the longest period of time.
Right.
I think in last time I checked in St. Pete, Tampa Bay area, the period of time is about 18 months, from when you request a hearing to when you get a hearing. And so then you finally get the hearing, and then you got to wait for the judge's decision. Sometimes that's weeks, sometimes that's months. So that was a very long answer to your question, but the short answer is typically it's about a 2 to 2.5 year process from the application of Social Security disability all the way to a notice of award.
Right. And sadly, I think that's been lengthened by the COVID pandemic.
Right.
I think it's created a backlog that does make things a little bit longer for your mom. So hopefully there's something that she has questions about. She could definitely give us a call at our firm at 727-796-8282. We'd be happy to talk to her about her options.
Yeah. Does that answer your question?
It does. Thank you so much.
Thank you for listening.
calling.
Yes, we really appreciate you listening. It does free up a line. Again, if you have a legal question, whether it's automobile accidents or slip and falls or workers' compensation claims, Social Security disability, or I don't know, Jacqueline and I could probably tackle just about any legal question. We'll take on the challenge.
We'll take a stab at it.
Yeah, give us a call, 727-441-3000.
Yes. And just point to that, the wait times with Social Security disability. I will say that sadly, even with the initial application, usually that only took a couple months, 3 months. And now I'm seeing it like double just to get the case assigned and reviewed, the initial application. So it is a very, very long wait,
right.
Unfortunately.
And it's frustrating, too, because you're not even eligible for Social Security disability until you've been out of work for about 12 months.
Exactly.
So you're out of work for 12 months, and then you can apply for Social Security disability.
Exactly.
You can apply earlier, but it doesn't make sense because
your chances of denial.
Yeah, you're going to get denied because you haven't met the first step. It's a 5-step process in order to go through entitlement to Social Security disability.
Exactly. So it looks like we have another caller on the line.
Good deal.
Caller, are you there? Can you hear us?
Yes.
Go ahead with your question. How are you?
Oh, pretty good. And you?
Doing well.
My question is, I'm on Social Security disability.
Mm-hmm.
At what age can I switch from Social Security disability to regular Social Security, or can I do that?
Right. So you're talking about, when you say regular, you mean the retirement benefits?
Yeah, I want to go from, I want to know what time frame can I go from Social Security disability to just plain old Social Security?
Well, Social Security will do that for you automatically. Once you reach the full retirement age of whatever that is for your date of birth, then Social Security will automatically transfer your Social Security disability benefits to your and reclassify them as Social Security retirement benefits.
Okay, I didn't know that. Thank you.
Yeah, you usually don't have to do anything for that to happen. The Social Security just does that by itself.
All righty. Thank you very much.
Absolutely. Thank you for the call. You have a great night.
Yes.
You too. Bye-bye.
Thank you. Yes, it does free up a line. We have about 10 more minutes left. We're happy to take any calls that you have. 727-441-3000.
Thank you. And then we're still streaming live. So if you don't want to hear your lovely voice on the radio, feel free to drop a comment on Facebook or Instagram. We are still here in the studio. So Social Security is definitely another topic that we definitely could answer a lot of questions on. So maybe we'll segue that to next week's show. We'll see. But it's another one that's very complicated, administrative law, statute based, and there's just so many different hoops and hurdles.
Right, and we get to meet people. I always, it's in our line of work, whether it's an auto accident or workers' comp or even Social Security disability, we get to meet the people at a downtime in their life, and so as a personal injury attorney, it gives me, the satisfaction of, trying to help these people when life is a little more challenging to them, whether it's because somebody rear-ended them and everything's all thrown up into the air about who's taking care of the kids, who's going to pay my medical bills, who's going to pay my mortgage since I can't work, or whether it's a work injury now that you're being treated differently because you got hurt at work or you have injuries that prevent you from doing it, or Social Security just said, you just can't work.
Right. And I will say, I think it's some of the most rewarding cases. People see billboards, say, oh, so-and-so got me $1 million. Well, that's not going to happen in a Social Security case.
That doesn't really happen that often in a personal injury case either.
But they glamorize that. But I think, like you said, when people have been, down on their luck for quite some time, they haven't been able to work, wish they could. They had worked years and years, have strong earnings, and had worked their whole lives until they became disabled. And they had to now fight through this system to try to get some semblance of normalcy and be able to, provide for themselves. And when you finally get them approved, to me, those are some of the most rewarding cases.
I agree 100%.
Yeah. You don't see it on a billboard, but I think they're the most grateful.
Yeah.
So.
And, and unfortunately, the public sometimes thinks that people on Social Security are just trying to milk the system.
Yeah.
So, so many of my clients say, gosh, if I could just work.
Yeah.
I just want to get back to work.
Right.
But they can't because of a disability, and it's a big cut in pay too.
Yeah.
So it is rewarding to get them the benefits. It is rewarding to, kind of be their voice, in a system that tries to shut them up. It's our job to be the voice of the injured,
I agree.
To let their story be told.
Absolutely. And I think that segues back into work comp in a sense that sometimes that's what you feel the adjusters might be doing.
Yeah. And the
It's trying to
employers,
silence, and the employers. And I think a lot of times they don't realize it as much as the carriers do, but the employers don't realize how much they're limiting their own, employees by some of the steps that they take. But with that being said, obviously, you can choose to get out of the work comp system by settling your case, right?
Sure. You can settle your case for a lump sum settlement.
Mm-hmm.
It's not like an auto case, though, where you go in front of a jury and they decide what the value of your case is.
Right. So there's no award coming from a judge.
That's correct.
Okay.
In fact, when workers' comp, if one side doesn't want to settle, the case stays open forever and ever.
Right.
My daughter is 34 years old, and I have a case that's older than she is.
Oh, my
It's
goodness.
been going on that long.
Oh, wow.
But that's because he doesn't want to settle the case. He's permanently and totally disabled. He's dependent on the treatment and the medication that they provide, and so he doesn't want to settle.
Right.
But you can settle the case.
Right. It's voluntary on both sides.
But the damages are different as well, though. In an automobile case or a slip and fall case, you get past medical expenses, future medical expenses, lost wages, future lost wages, pain and suffering, mental anguish, loss of enjoyment of life, and all those other things.
Exactly.
And you can ask a jury to award you that.
Right.
In a workers' compensation case, you don't get that. You get future medical expenses.
That was going to be my question. So if you don't get that, what do you get?
That's all you get. In most situations, it's all you get is future medical expenses.
Wow.
There may be some indemnity. If you're permanently and totally disabled, then you may be able to incorporate
Try to factor that in.
Yeah, those indemnity benefits into the value of the settlement as well.
Right.
But for
or
the
maybe
most part,
any unpaid past benefits, like maybe mileage or smaller things, but they're very, very few.
Very few. And so the workers' comp settlements are dramatically smaller
Absolutely.
than any personal injury case.
Right.
One thing that they almost always include in a workers' comp settlement is resignation from your job.
Bingo.
Yeah. If you settle the case, they oftentimes, I would say 99% of the times, make you resign from your job.
And a lot of people don't realize that. They think, well, I can just take a settlement and keep on working.
Right. And a lot of times it's the insurance company. It's really not the employer, it's the insurance company.
Right. The employer might want you to stay. They might need you.
Yeah.
But unfortunately, you have to resign as a part of the settlement agreement.
I've heard two reasons for it. One I believe and one I don't really believe.
Okay.
The two reasons I hear why resignation is required is because if injured worker number one gets hurt and then he gets a lump sum settlement and he goes back to work and he tells everybody he has a lump sum settlement, then there's going to be more claims.
Right.
I don't buy that.
Other Tommy worker got hurt too. And then Billy got hurt too.
Yeah, I don't buy that. But I can't accept that if you get hurt at work and you injured your back.
Yeah.
And you settle your case on Tuesday. You go back to that same job and you hurt your back.
Right.
Well, then they buy the back again.
And that's what I've always explained to my clients.
And the insurance companies don't want to do that. And
exactly.
But a lump sum settlement is possible. But I call it divorcing workers' comp. Pay me something and I'll go away and you and I will never see each other again.
Right.
And so those are cases that can be done. Should be done with an attorney instead of just the adjuster.
Absolutely. And just so I'm clear, a lot of people don't realize, especially like nurses and those that work in the medical field, they work for big corporations or big conglomerates that like a Baycare,
right?
Or where they're connected to large networks. So you're not just resigning from your little practice or the
Dr.
clinic.
Jones, who works under Baycare.
You are resigning from the entire company, the entire corporation, which means you can't go back and apply and work for any other Baycare facility. I'm just throwing Baycare out there. And so people don't know that either.
Right. And I had that situation in a leasing employee company. They got hurt and they were a leased employee. And we reached a settlement. Well, they wanted to go back to work at ABC store, but ABC store uses the leasing company for their workers' comp, and so he wasn't able to go back to. He wasn't able to take the job at ABC store.
Exactly. So those are all the things that you really have to consider. Is it a good idea to settle your workers' comp case?
And sometimes it's not.
Yeah. And the good thing about it is if you don't, like Matt said, it will follow you for life. As long as you keep your statute of limitations open. You can explain that.
It's supposed to follow you for life, but there is a statute of limitation. The initial statute of limitation is 2 years. If you don't have any treatment for 2 years from the date of accident, then workers' comp is off the hook and they don't have to provide any benefits. If, however, after the 2 year period, as long as you see one of their authorized treating doctors, not your own doctor, their authorized treating doctor, as long as you see one of their authorized treating doctors or they provide care at least once a year, the statute of limitation keeps going on.
Exactly.
So
if you go a year and a day and your appointment was, the day after your statute ran, your case is closed. You won't be able to see that doctor.
That's right. Now, there are little caveats, though. I mean, if they give you a prescription and then they fill that prescription a week later, you may be able to buy yourself.
Or if you got like a check or your impairment benefits or something, I think that check would also qualify if you received it. That could keep your statute open too.
Yeah, that's true.
So those are all things to consider. We are winding down, but I don't know that we have more time. But if you're in the comments, you can definitely comment any questions as we wrap up here. But again, I think the workers' comp system definitely has a lot of hoops and hurdles, and it should not be something you go alone. Right, Matt?
That's right. And even though we're not here every hour of every day of the week, we are in our office. So if you have a question, call us, Pernick, Caulfield, Averill, and Noyce, the oldest personal injury law firm in Tampa Bay. And you can call us at 796-8282.
Right. Don't call the radio station.
Yeah. Bobby will have to answer all those.
I'll pass them over.
Jacqueline, thanks for letting me be on your show.
Absolutely. If you want to find us on the web, our website is usalaw.com. Thank you once again for tuning in to FLA Law on the radio. And we will see you guys next week, this time, 5 o'clock on Tuesday.
Good night. Drive safely.
Good night.
Bye-bye.
WTAN, Clearwater.
FM 106.1.
WDCF, Dade City.
FM 102.3.
WZHR, Zephyrhills.
FM 104.3.
Listen.